Well,
So let's talk about this very interesting case because
yes.
it seems as though a judge has put his foot in the mud of the vaccination debate, COVID vaccination mandates, and how that might affect the rights of parents to have relationships with their children should they avoid a vaccination. So why don't you introduce the case to the viewers, and we'll take it from there.
Okay, so the case is named AG and MA, where the names are not, sometimes that's done to protect children. And it was a case decided by Justice Robert Spence of the Ontario Court of Justice. And it just came out on October 27th, so it's a pretty recent case. And in this case, we had a situation where the mother brought a motion and she was seeking to suspend the father's parenting time, in-person parenting time, with their 2-year-old daughter. And just by way of background, prior to bringing this motion, the parties had a consent order in place where the father was to be getting 2 hours of supervised parenting time per week. And just some additional information that was relevant for the court is that the father had received one dose of his vaccination, and he had a letter from his family doctor, sort of a one-sentence letter indicating that he had a medical exemption for getting the second dose. That's really all it said. And the 2-year-old child is, I would call, immune compromised. The child has asthma, so there's some issues in terms of the child being susceptible to more complications from things like COVID and whatnot. And the mother, I guess, the mother found out that the father didn't have his second dose. She wasn't aware of it, but he had, I guess, written to the supervision center where he was supposed to be exercising his supervised access, or to the party, the supervisor. And he had asked something about because of the weather, could it be moved indoors? And he only had a single dose of his vaccination. And that's how the mother got wind that he wasn't fully vaccinated. And that's what gave rise to her bringing this motion.
And I'll tell you, I read this case with interest from a number of perspectives, and I'm going to share one with our viewers and with you, Leanne, that judges are legal experts. They're not health experts. They're not medical experts. And in the last 2 years, we've seen some judges desperately try to stay away from holding forth on whether they can opine on the health-related concerns involving COVID and involving vaccinations and anything related to COVID. But in this case, I have concerns with how this was handled. But I'm going to start by saying I'm not sure there was a right answer, and I'm not sure there was a wrong answer. But I'm going to say to you this, that let's first go back to the facts of the case. This is a father that was granted very little contact with his child. He was granted supervised visitation or supervised parenting or supervised access. And it was going to be access that he could only spend 2 hours a week with his child in the presence of a professional supervisor. So already this was a parent that had very limited contact imposed upon him, limitations imposed upon him by the court. And when the supervisor got involved, of course, the supervisor has to communicate with the parent that's going to have the supervised access. And so he writes to the supervisor and says, I want you to know that I've only been vaccinated once. I have not been vaccinated for the second time. And is it possible to work around the circumstances of visitation? And he adds an extra concern. He says, plus I can't afford it. So give me some accommodations. So right away, unto itself, this was sort of, he was writing his own demise when that happened. Because what ought to have happened from the get-go is he should have made full, frank, and complete disclosure, A, about the fact that he was not fully vaccinated, B, about the fact that apparently he had some issues with respect to the reaction he had to the vaccination, and then thirdly, that he had some other physical or medical concern with respect to what is called helicoptis polyp something, bottom line,
Eye or something.
some sort of bacterial infection. When that is combined with the fact that the child has a respiratory disorder that could be susceptible to this very bacterial infection, right away unto itself, this was a recipe for disaster for this father. It wasn't as though he didn't know some of these things. He knew some of these things, and he didn't disclose it. And then the mother found out about it only indirectly when the supervisor got wind of it from the father, and the supervisor then reported it to the mother, who then brought this before the court on an emergency basis. So this was doomed from the get-go. That's not my problem with this case. My problem with this case is if it's true that the child was immunocompromised, the father did not make full disclosure, and the father's rights needed to have been curtailed in order to protect the safety of the child, then here's my problem. Why is it that the judge allowed in-person contact from 120 minutes every week to 60 minutes every week by doing it outdoors? If indeed the child is at risk, wouldn't the child be equally at risk within 60 minutes? Do you really need more than 60 minutes to potentially infect the child with COVID? And so how is it that the judge made the analysis that in order to protect the child, I'll reduce the time and move it outside? Is that a legal analysis, or is that a health analysis? And
Well,
that's
it's definitely a health analysis. But I mean, and I think that my sense was the judge here was trying really hard to balance a bunch of factors, looking at the global best interests of the child. And, the judge does make the comment that, it's beneficial for the child to have some sort of meaningful time with the father, and that having it via screen time, having it on Zoom or FaceTime or however it could be done virtually, doesn't have the same sort of connection and meaning to it that in person does. So I think the judge was just trying to find some sort of compromise to allow the child to still have more of a meaningful time with dad, and made the decision that moving it outdoors but lessening the amount of time was the health risk to the child, the whatever amount that was, it was offset by the greater benefit of still having some contact with dad rather than having just virtual contact with dad. And
yes, yeah.
Really, that's anyone's, it's a random opinion, right?
Yeah, the judge struggled with it.
Yeah, if you were on the bench, you might have decided it differently.
Yeah, and I'll tell you, if you put this in front of 10 judges, you're going to have different decisions.
Yeah.
And this judge, who, by the way, is a very good judge, very seasoned, very knowledgeable of the law, and he's a tireless judicial officer attempting to do justice to this family and to do justice to every person in this family, mom, dad, and child. So I think the judge's efforts receive a star. As for the legal analysis, however, I do, however, believe that the judge stepped outside of the legal arena and into the health arena when completing his decision and granting a remedy. Now, with that said, however, I want to give the judge a check mark for doing significant research that actually went into the fact-finding and the analysis. And what do I mean by that? Well, the father came forward and said, I had a negative reaction to the first vaccination. And as a result, I chose not to get a second vaccination. And the father put forward medical evidence, although the judge didn't find it to be particularly weighty, but the father put forth medical evidence that he went to a doctor, and the doctor sanctioned his decision to not have a second vaccination. Okay, fine. So what did the judge do with that evidence? The judge went and researched under what circumstances can somebody avoid a second vaccination legitimately. So the judge goes and researches that very subject matter under Ontario public health care standards and finds that the healthcare standards do recognize people avoiding or choosing to not have a second vaccination, but under certain circumstances where the evidence substantiates that decision making. And then the judge finds in this case, on the facts of this case, that the father hasn't met the onus of proof on the evidence, which I think is very well done.
Yeah. And he also, the father said he went to the hospital, but he provided no documentation. The judge notes this. There's no documentation showing a visit to the hospital after getting the first vaccination. So, you know, I think the judge raised that in addition to this additional research. So, and it seemed to me like the judge kind of went above and beyond because the lawyers had not provided this information. He makes note of what the lawyers did not provide before the court, or what the parties did not provide before the court, and the judge took it on himself to go beyond what was there, go beyond the record, and do this additional research to try to arrive at a decision that, you know, is in the, you know, best interest of the child and complies with the legal requirements and the health requirements.
So our viewers are probably wondering, all of these lawyers, all of this talking head business, what's the takeaway? And I'll tell you, this is one of those cases where I could see it could have easily gone viral, where people could have taken from it what they wanted the conclusion to be. For example, if you don't get vaccinated a second or third time, you might lose your parenting rights. That's not the conclusion that one can draw from this case. So I want the viewers to be very careful in recognizing that this was a facts-driven, unique case based on a particular set of facts that may not be widely applicable. But what can be taken away from it is that if a child is immunocompromised and susceptible to any form of reaction, medical reaction, whether it's due to COVID or something else, and a parent doesn't act reasonably in ensuring that the child is safe in their care, and if a parent wants a judge to believe that they have acted appropriately, then that parent will need to marshal the necessary evidence to convince the judge that they have done everything right and nothing wrong. And in this case, the father simply fell short on the evidence.
Yeah, exactly. Now, I noticed we did have a question earlier on from J. Kasler 23. What if the co-parent does not share her vaccine status? And, you know, that's an interesting one. Does a parent, I would say that a parent has an obligation to share their vaccination status with the other co-parent if they are to be able to co-parent effectively in the current world we're in with the post-pandemic world. I don't know if you have a different thought on that, Steve.
Well, it's an interesting question in other legal spheres. In other words, does an employee, can they be mandated to disclose to their employer that they have been double vaccinated? Does a person who is crossing an international border have to disclose to the border authorities that they're double vaccinated? So now when you think about, and I can go on, if you think about those other legal constructs, how does the relationship between two separated spouses fall on that spectrum of disclosure? And my answer is your answer. I think in this situation, a parent needs to let the other parent know what their vaccine status is. Now, there has not been law on that, and I'm not so sure that this case stands for that proposition, although I do have to say that the judge certainly made a note in his decision that the father did not, prior to the hearing, disclose that he even had one vaccination. And it was only during the hearing that the father's lawyer emailed to the mother's lawyer the proof of the first vaccination. And I think the judge frowned upon that conduct, which simply added to the matrix of facts to support the conclusion that the father simply did not act appropriately and make full disclosure. But to the question from one of our viewers is, what is the law on that? We don't have an answer because it's not been made clear that one parent owes another parent a duty of full disclosure of any of their medical information, let alone their vaccine status. But again, we're in a world right now where many other people and authorities, governments, employers, institutions are indeed forcing that disclosure. So if that's happening in the other realm, I would think that it most likely would be considered to be required in the family law realm as well.
I agree and think so too.